Well, full disclosure, I'm joined by my business attorney, Brian King. How are you, my friend?
I'm doing well, thanks.
Fantastic. Brian, how long have you been practicing law in the CSRA?
Well, in the CSRA, a little over 15 years, total, a little over 20 years.
Wonderful. Well, I understand the array of services that you provide and have worked with you for many years. But for those folks who maybe don't know, what are some of the type of things that you'll do for clients?
Well, I review and draft contracts. I advise business owners on how to protect their assets and grow their businesses. So, I review leases, draft them. Just really, if somebody's buying or selling a business, I'll draft the documents and advise them and help negotiate that deal. So.
Excellent. Why don't we start at the beginning in case anyone's watching that is thinking about going into business.
Mm-hmm.
How do you get started?
Well, it'd be nice if they would call me first before they go to LegalZoom or any of those other organizations online. But, I will, draft, I'll prepare I'll form the company for them. I'll get their EIN number and talk to them about their business and try to help them avoid roadblocks that they may or may not be, thinking about, and draft the contracts that they'll need to protect themselves going forward.
Yeah, you mentioned EIN. How interesting, employer identification number. I get asked that a lot because we formed Augusta Business Daily LLC. Why is that number, the EIN number, so important?
Well, to file your federal taxes, you have to have it, and then you also need it for a lot of other things like opening your business bank account. They're going to want to see that along with your other organizational documents before the bank will open up your account. So.
Yeah, and I guess one of the next steps after you help form the entity, you mentioned leases. Are there just a couple of things that you've seen through the years that are in leases that maybe people who are going to rent office space or rent at a strip center, maybe they make a mistake and they sign for?
One of the biggest things is the term of the lease. So when you're just starting a brand new business, you don't want to agree to, say, a 10-year term or something like that when you don't even know if your business is going to be successful in that many years. You want to try to aim for, say, a 1 to 3 year term if possible. You want to look at some condition of the premises and whether it's going to meet your needs and for the growth that you expect to have in that period of time. You want to check into possible renovations that could be done by the landlord, and maybe there's some money that they could put towards that to make it meet your circumstances. And then things like the HVAC, you want to make sure that is going to be covered in the lease, where if the HVAC is old and needs to be replaced, maybe you can negotiate to get the landlord to go ahead and replace that, or provide some sort of allowance for if it breaks down within a certain amount of time, that they would cover that.
So in our lease, our headquarters are at 930 Stevens Creek Road, and it says that if a technician has to be called out, up to the first $500, we're responsible. Is that standard?
Yes, and that dollar amount can vary based on the lease, but that's basically if you maintain the unit, and then if it goes above that, say, the $500 mark, then the landlord comes in and either they can decide whether they want to replace it or spend the extra money to keep repairing it.
Right. And about contracts, what do you think businesses should enter into contracts for? Like, are there some specific reasons to have a contract, or maybe the top 3 reasons?
Well, to define what services or products that you're going to provide the price that those services or products will be provided at, and the payment terms, if they're going to be paying over, monthly, like a subscription type service or that sort of thing. A lot of miscellaneous provisions that get added in by me when I'm looking at these documents that, sometimes the contract, there's certain elements of the contract that need to be particular to a particular industry, whether it's the music industry or the, construction industry or whatever. There's certain terms and all that are kind of, that go into those. But then there's also some miscellaneous provisions like, jurisdiction. Where are you going to litigate if there's a dispute? What law is going to govern and, that sort of thing. So, those miscellaneous provisions, which there's, a lot of them, tend to get tacked on at the end, but they're very important to have.
Yeah, you mentioned that, and I have a close relative that we're working out arrangements for Augusta Business Daily LLC, and we don't ever, God forbid, have a problem, want to go to court. So we thought of kind of mediation, arbitration. What would the difference be between those two, and is that a good step before you have to go see the judge?
Right. Well, alternative dispute resolution has become very popular in the last years, and because it takes so long to get things resolved in courts today, and you never know what a judge or a jury is going to do. So to try to speed up the dispute resolution process, and to have a little more certainty about what kinds of things are going to be considered and what's going to happen. A lot of times people will put in arbitration provisions or mediation followed by arbitration provisions. So yeah, I mean, it really is, because contracts is just up to the parties as to what they want to put in there, and the court will enforce those arbitration provisions or alternative dispute resolution provisions. So, if you if you had to go to court to enforce them, to compel arbitration or whatever. So, there's certain organizations like the AAA or not the car one, but,
sure,
but other arbitration methods where they have certain rules and procedures that are already set forth, and you can kind of opt into those existing ones, or you can create your own.
Yeah, and of course, we all the time find that companies are selling their business to a family, and the family comes in. And so you mentioned the buy-sell agreement. How are both sides protected in that? And do you recommend really taking your time with that?
Sure. Yeah. I mean, so a lot of times a buy-sell will kick in when one person dies, and then the remaining business owner will buy out the other one, and they'll pay money to that person's estate, and then they'll continue to run the business without that person. But they make sure that person gets the value of the business that they held, right at their death, and so the buy-sell provision will set forth the way that payment is calculated, or the way that value is calculated, and then the payment terms, whether it's paid all in lump sum or whether it's paid over a period of years because it's a tremendous amount of money. Maybe it's worth millions of dollars. So you may trigger a promissory note payment, that pays the value over time. But you could have triggers because of bankruptcy filings or divorces, things like that. So.
Well, the best way maybe to get in touch with Brian is he has a website with a lot of good resources at businessattorneylaw.com, businessattorneylaw.com. Brian, thank you so much. And before we scoot, so it's your first time in the podcast studio.
It is.
What'd you think?
I think it's great. Yeah. This is a very neat way of communicating with my potential clients. So
excellent. Well, we hope that folks get in touch with you, and we thank them, David and Chris, and their website is AugustaPodcasts.com. That's AugustaPodcasts.com. Well, we're continuing with business attorney Brian King, who has been an attorney in the CSRA for more than 15 years. And how are you?
I'm doing well, thanks.
Great. The last time we chatted, we pretty much went from the beginning of a business when you get started and you form a company to be legal, to get an employer identification number through contracts, and then a buy-sell agreement as well. Nowadays, when we're in the pandemic and you have people that you are trying to hire, And you don't know whether they're employees, you don't know whether they are contractors. How do you sort of determine what determines whether someone should be one or the other?
Well, it's mainly an element of the control that you're going to have over that person. So if you're going to be supplying the tools and the resources for that person to do their job, you're going to be supervising them and, kind of telling them, hey, you do this and then do this and do it this at this time and all of that, then they're going to be more like an employee because you're exerting a lot of control over them. If it's more of, hey, I'm hiring you to do this job, and they come in and do it, and you just kind of, okay, make sure that it's done, and then you pay them. That's more like an independent contractor. And so in the agreements with employees, for example, you could include non-compete provisions, non-solicit, and protect yourself. So you try to keep that employee from going and starting their own business competing with you, particularly if it's maybe it's a sales position where they've got a lot of contact with your clients, and you don't want them to just run off with your clients and start their own practice. So.
Out of curiosity, I remember from the TV business, I think it was a year that I could not go to work across the street to the competing TV station.
Right.
How have things changed? Like, what range of time is pretty typical and standard?
For an employee relationship, so the non-compete will last during the term of the employee's employment. Mm-hmm. And then after the employee is terminated, it can last for up to 2 years. And that's a very standard, accepted by the courts provision.
So 2 years is not too long to ask an employer or contractor.
And then you contrast that with the sale of business context, and 5 years is a typical non-compete period.
I see. Now, does it matter whether the person is working in your office or working from home as to determine whether it's employee or contractor?
It can, if to the extent of control again. If the person is working at home, you probably have less control over them. Although in today's current COVID environment,
sure,
a lot of employees are working from home now, and they're still employees, and they're still having to report in to their employer a lot, and they're checking on them, and they're having Zoom meetings and all this stuff, and so that by itself is not a determining factor on it. There's actually several factors that the IRS looks to determine whether a person is an employee and would thus get a W-2 at the end of the year, or whether they're an independent contractor and would get a 1099 at the end of the year. And so the IRS just looks over those factors, and then the courts, will look at those too, but they look at the control.
Sure. So, and who determines whether someone might be a full-time employee or a part-time employee? Are there standards for that?
Well, generally full-time, people think of, 40 hours a week, and
sure.
That's
9 to 5, right?
Right. Exactly. So the Fair Labor Standards Act, can apply to certain employees where if they work more than 40 hours a week, then you would have to pay them overtime. For purposes of benefits like health insurance, 401k, and that sort of thing, 30 hours is usually considered full-time, and the person would qualify or be able to have those benefits if they work at least 30 hours a week. Sorry.
Okay. So using that example, let's say someone is agreeing to work 30 hours a week and they're an employee. Usually it's a 2-week pay cycle. So what happens if they only work 20 hours the first week? What occurs?
Well, sometimes with the benefits, they have to work there for a certain period of time before the benefits kick in. So sometimes it's 60 days, sometimes 90 days, sometimes it can be a year before they can get a 401k benefit. But it just depends on the employer. But if they are generally meeting the hour requirements, then 1 week of not getting there doesn't keep them from being a full-time employee.
Sure. And how about just the amount of time? Do you recommend paying them a salary for those 30 hours, or do you recommend an hourly?
Depends on the job and how the business is kind of operating, really. You can pay them by the hour, or you can pay them a salary. It really just usually the managerial employees are more leaning towards the salaried employees, and then the and the more manual labor it is more hourly usually.
Right.
So,
wow. And have any interesting employer-employee situations in the last 18 months come up? Have you heard of any COVID-like situations, or clients of yours just talking about trying to find labor? And
well, there has been seems to be like a shortage of labor in the market right now, and primarily for the lower paid jobs. I mean, so like working at McDonald's or fast food restaurants.
Sure.
I've noticed that they've started increasing the pay, up to $10 an hour for working at McDonald's, but they still have trouble finding employee. And I actually went through the drive-through a couple weeks ago, and they say that they were going to close at 8 p.m. that day because they didn't have enough help.
Right.
And so, yeah.
Wow, that's definitely interesting. And how do you determine whether you should pay an employee overtime or not?
Well, if they're an exempt employee, you don't have to pay them overtime, and it's usually those managerial employees that would apply to. But there's all kind of rules about that, and I've even had been involved in some lawsuits where there was claims that overtime should have been paid and it wasn't, and then there's usually there's a lawsuit, and then there's negotiation, and then you calculate what the pay should have been, and you usually settle for somewhere in between. Is usually what happens. But whether it's time and a half or extra time off. Maybe. Well, the comp time, doesn't quite work, or it doesn't solve your problem of not paying overtime. But, the calculation for overtime under the Fair Labor Standards Act, when you go to calculate damages, is actually slightly different than the calculation that you would do when you're calculating how much money you have to pay that person for overtime when they are, working, and when say, I guess you'd say, before lawsuit and damages.
I follow you.
Yeah.
Yeah. Before we scoot, any last words of advice for employers or employees or contractors, just from a legal standpoint?
Well, just you just have to try to define the relationship with your employees, and that can be with starting from your offer to them as far as what they're going to be paid and what work they're going to be doing, what your position is, and maybe a job description. And then you could have a employee handbook, and you have your policies written in there, have the employee sign that they have read and reviewed and read the policies, and they're going to comply with them, and then use write-ups if the employee violates the policy. Talk with them about it, write them up if you need to, and if they violate it numerous times or even one time, you can terminate that employee. Georgia is an at-will employment state, and South Carolina is as well. So you can fire the employee for any reason that's not unlawful, such as race or something like that.
Right.
So,
discrimination.
Right.
Age, things in that regard.
Right.
Fascinating. That's great. And Brian's website is businessattorneylaw.com. Businessattorneylaw.com. Take it from me. Go see him on the front side of your dealings rather than after things occur. Save a lot of time and money that way.
That's
don't
right.
you?
That's right. Yeah, I always try to remind my clients to talk to me before they sign something versus afterwards. Yeah.
Thank you, Brian. Appreciate it.
Thank you.